Welcome to Infringe at Your Own Risk.
Hello and welcome to Infringe at Your Own Risk. My name is Kevin Rosenquist and I am here with Rand Bateman of Bateman IP. Today we're digging into infringement, what it means and how you can steer clear of it. Rand, great to have you back.
Great to be back. Thank you.
So what is infringement? What does it actually mean in IP law?
So in IP law, infringement means you violated the rights of another party. So, patent infringement would be you violated somebody's patent. Copyright infringement, you violated their one of the standard protections they have under the copyright law. Trademark infringement, you created a likelihood of confusion or dilution regarding someone's trademark. Trade secrets, you somehow got somebody's trade secrets and used them improperly.
Okay, so it's essentially getting in trouble for what you do to protect people.
Exactly.
Yeah. Okay. Can you give examples of each of the ones you just mentioned, just so that our listeners can kind of understand or relate to what each one is?
Yeah. So let's break it down with patents. Remember, there's three types: utility patent, design patent, and a plant patent. Within a utility patent, there are two common types of patents. There is a kind of a product. So either a system or a composition of matter, something that has been made. And then there's a process. So with respect to the something that has been made, if I make a web camera and somebody else owns a patent on web cameras and their patent says, lists the things in the claims. So at the end of a patent, there's a list of claims. And it's kind of the equivalent up to the property deed that you get when you buy your house. Only it's describing the invention in words. And they go through a checklist. And if every word of that claim reads on your device, then you infringe that claim. So, for example, if the webcam company had a patent for a lens that was concave. Usually you see a lens, it's flat or slightly rounded, but let's say there's something cool that you can do with a concave lens. And so they claim a webcam having an optical sensor with a concave lens. So then they would take your product and compare it and says, well, it has the optical sensor. Does it have the concave lens? And if your lens is flat, then you say, no, I don't infringe because my lens is flat. And other times they will say, yeah, it is, or they'll argue why yours is substantially the same. I've got a case that's been going on for 6 years right now, where the patent is a method for building an ice structure. And it's basically using icicles to build an ice fort. And they sued our client who makes ice structures that people come and see in the wintertime. But they make them they take long tubes of plastic and fill them, freeze them, and then cut them up into ice logs and make it. And so they're suing my client, and there's a dispute as to whether my client's ice logs are actually icicles within the meaning of that patent. Oh. So that's been going on for 6 years and has cost an immense amount of money.
Wow.
And so, huge fights can occur over a single word or the definition of a single word. So that case is actually on appeal to the federal circuit, and we'll see in about 6 months how that turns out.
Wow.
But yeah, and companies can spend huge money. We've had multiple damages awards in patent cases of well north of $1 billion. So yeah, real money can be involved. Apple and Samsung, the judgment in that case was $1 billion over the Samsung phones because they look too much like Apple's. Okay, so we talked about that. So there's a product. There's also a process. So the process by which I make something. Sometimes if you can find a better way of making a product, it could be just simple soap. Right. I have a way that I can make soap that's 20% more cost effective. If you own that process, okay, you're going to make a ton of money because you can undersell everybody. but your competitors are obviously going to say, "Hey, we'd like to do that." And sometimes hanky panky occurs, and people get hired away from companies to bring information. Sometimes people get stupid and take information. Years ago, there was a case where an employee at Coke decided that they were going to take Coke's secret formula and go to take it to Pepsi. What they weren't counting on is that Pepsi was stand-up company, and so when she showed up to turn over the secret formula, the people that she turned it over to were actually police officers.
Oh my gosh! Whoa!
And dressed up like Pepsi employees, and she did jail time. I think 5 or 6 years in jail.
Wow, 5
for
or 6
stealing that.
years.
So it can be a big deal, and it can be huge if you can take somebody's process. And so that's why companies will have people sign non-disclosure agreements and that. But having that patent there, if they can prove you're following the same method, they can sue you for infringement, and the damages can be huge. I have never seen a plant patent infringement case. I'm sure that they have happened, but like I said, plant patents are very rare compared to the other types. Design patents, there's been some really big cases fighting over designs of things, from chairs to pool equipment to there's one I saw that was over enclosures for trampolines. So those can be substantial as well. The best thing for design patents is if somebody's going to rip you off in today's day and age, if you've got a relatively simple product, it's going to go to China or Vietnam, right? They're going to take your product, they send it over there, and they copy it verbatim, and then it comes back in. And so design patents, they're fairly narrow, but the good thing about getting them is if somebody does that, they're easier to enforce, because it's just a look at, does this look like that? That's basically the test.
Mm-hmm.
Would somebody be confused if they saw one and then saw the other, that these kind of emanate from the same source, or that idea?
I feel like that happens a lot, where you look at something and you're
Oh,
like,
yeah.
boy, that could be the name brand. That's crazy.
Yep, exactly.
The
And so if
packaging,
you've got
everything.
that patent, you can go to the ITC and shut them down. Or my experience has been that Amazon and other online retailers are quicker to enforce a design patent than they are a utility patent, because they don't want to be in the game of, is the ice log an icicle, right? They want to, but they can look at it and say, yeah, these are pretty much identical.
Yeah.
They clearly copied theirs, and then they'll often just shut it down and say, no, we're not going to carry that product because it's clearly a knockoff and would infringe. So design patents can be beneficial. They're cheaper. They used to be much faster. We used to get design patents issued all the time in 6 months to 9 months. I've got one. I just got a call from the patent examiner. We filed in 2021, and she's just examining it now.
Is that because they're just so far behind?
Yeah. I really wish they'd hire a lot more examiners. The problem for the patent office is somebody goes in, they become an examiner, and after a couple of years, they can get hired out by a DC law firm making 2 or 3 times the money that they'll make as an examiner. I mean, they don't get paid bad or poorly. They just don't get paid what associates in really big DC law firms.
2 to 3 times your salary is 2 to 3 times your salary. So regardless of what it is.
So it's like, all right, well, we will just we will go over there, and and
hard to blame
it's
'em.
more prestigious because now I'm at big DC law firm instead of I'm a patent examiner. A lot of the patent examiners actually are going to law school. They'll go to law school at George Washington or GW or some of the other schools right there in the DC area, and then and work as an examiner. So they'll go to law school at night, examiner by day, but they're going to have them about 4 years, and then they're going to graduate and make a lot more money in private practice than public. So yeah, we wish we had a bunch more of them, but we do what we can. Yeah, it's there's just a lot of patents being filed, and an awful lot coming from foreign countries.
Yeah,
China is filing a huge number of U.S. patents. Okay, so there was patents, copyrights. In a copyright infringement, it's whether a ordinary person would consider that expression of substance has been taken. And those can be difficult cases sometimes, and sometimes they're really easy. Sometimes people are stupid when they infringe. Like I had one case where they had copied, my client made coupons for businesses. And these people copied the coupons, and they claimed that they didn't copy the coupon. And then when I called their counsel and I blew up the image, and you could see my client's copyright notice in their coupons.
Oh, whoops.
And I said, yeah, I think that there's that. I had another case where it was an architectural copyright. So somebody designed a new house, and somebody had copied it and built that house like 2 blocks away. And this was a high-end home. It wasn't, your typical tract home. It was, this was $1 million home back in the early 2000s.
Mm-hmm.
And, the guys, I didn't copy it, swore he didn't copy it. Well, he had added on a kitchen nook on the back with a bedroom above it to the design, but he had forgot to change the other plans. So there was a 8x10 bedroom with a beam running at a 45-degree angle right through the middle of the room if you put the plans together. And as soon as I showed his attorney that, they settled.
They settled, yeah.
Yeah, they denied, we had nothing to do with it. We didn't even see your client stuff. It's like, really? Well, and I told him we were coming up to the deposition. I said, I'll tell you what my first question is going to be, just so you can prep your client for it. Why is there a beam coming at a 45-degree angle through the middle of an 8x10 bedroom?
Yeah, that's not good planning. I wouldn't want that.
So, but copyright cases can be really, really fun, really interesting. A lot of times people don't. One of the biggest things with copyrights is that small companies assume if I paid for it, I own it, right? If you paid for it, you own the physical copy of something, but you don't necessarily own the copyright. So people will pay for something and then they'll start making copies. So if you hire an outside company to do software for you, okay, that doesn't give you the right to license anyone else to use that software, unless you have something in your contract that gives you the ownership rights or the licensing rights to it. And so you'll get people, I've had companies that, they build a whole product line based on some cartoonish characters that were drawn by somebody else. And then all of a sudden they get a lawsuit because I never said you could make all of these copies of my work that you're using now. So it's really important, if you're a company and you have anybody outside your organization doing creative work, that you have a copyright agreement with them as to who owns the rights to use it. Do you? Yeah. Do you not? It's really bad if a company just takes off and they're doing great and they're making millions of dollars, and it's all based on something that someone has a claim as copyright infringement.
Oh man!
Because then all of that gets clawed back.
That would be a bummer for sure.
Yep. But it happens all the time, unfortunately.
Yeah, I'm sure. And then let's see, what do we got? We got
trade secrets.
Trade secrets and trademarks, right?
Oh, trademarks. Okay, yeah. So trademarks. Trademark infringement is basically the likelihood of confusion test. Is it likely to create confusion? You can use somebody else's trademark as long as it doesn't create confusion. So, for example, a mechanic can say, I service Ford cars. That's appropriate use of somebody else's trademark because you're just making a factual assertion. But if you gussy up your garage and have, the stylized Ford logos and you make it look like it's a Ford dealership, then you're going to get sued for trademark infringement. Okay. Because the public's going to be confused. Are you affiliated with Ford? Are you associated with them? So that's, the key is, as long as it's clear to them, hey, I work on Ford cars. I'm not associated with Ford. I work on Ford and Mitsubishi and Toyotas and Hondas. Okay. That's perfectly appropriate use. One thing that always likes to happen, the NFL loves to squeeze people about the big game. One of the first projects I worked on, even before I was a lawyer, was, them threatening somebody who was selling Super Bowl packages. Travel company, you'd fly in and where the game was and whatnot. Often I've seen them kind of stretch their rights beyond where they really go. So if you get a threatening letter from a trademark attorney or from an attorney about a trademark, consult your attorney before you do anything, because sometimes they're full of it. They're just
Mm-hmm.
making stuff up. You're not really infringing. It's a proper use. The other thing that's important, one of the biggest things that bugs me on the internet is there are people who are advertising trademark services who will say, you know, if you haven't registered your trademark, you've lost it. That's actually not true. Trademark rights spring from use, not from registration with the government. So if you are using a trademark before somebody else, you actually have superior rights to them in the areas that you've been using it. The importance of getting a federal registration is that you're getting the registration across the entire country. So if I start my company and I use it in Utah and Nevada and California, I may have trademark rights there. And then somebody else comes out and they start in North Carolina and Virginia and Maryland, right? You can have two companies that have the exact same trademarks that can both use the mark. The problem is, as they move towards each other, you get a likelihood of confusion, and then you can end up with an agreement that no, you have to use the mark in this part of the country, and you have to use it in that part of the country. If you register your mark, though, as soon as you file your registration application, that gives notice countrywide. And once you have your registration, you can get countrywide, except for the people who were there first. They can challenge that and say, no, I was here first. My rights supersede. So there were a couple counties, I think it was in Oklahoma, but somewhere in the Midwest, where there was a burger joint called McDonald's that was there before Ray Kroc and et al. Got McDonald's going, and so they actually had rights. McDonald's couldn't build a restaurant in their area because they had prior rights.
Wow, that's crazy.
So if you have a trademark conflict, talk to an attorney, because there's a lot of different issues that come into play. How similar the marks are, how similar the goods and services of the two companies are, who started first. When I was a wee attorney, one of the guys who helped train me, taught me the first rule of trademark law: know who you used it before you assert anything.
Mm-hmm.
Because, and I've seen this happen where somebody will write my client and say, "You're infringing our trademark. We demand that you immediately cease and desist." Yada yada yada. Well, it turns out my client was using it 5 years before they were. So they have now admitted in their letter that there is a likelihood of confusion between the two marks.
Oh.
And my client has prior rights. So it is really fun to write the letter back. Thank you for your acknowledgement that your client is infringing my client's rights, as my client started 5 years earlier. We expect that your client will cease use of this mark in the next 60 days. Probably not what his client wanted to hear.
Probably not.
So
Probably not.
So it's really important to do your due diligence and stuff before you make a decision one way or the other.
Right.
I've had some where the client was ready to just give up. Okay, we'll change our market. I'm like, why? You have priority over them. And they're, oh, really? So get good legal advice before you make any decisions on things like that.
No doubt. All right, so we have about a minute left. What can you give
Okay.
me a quick synopsis of the trade secrets? How someone might infringe on that?
Yeah, trade secrets is: did you improperly use somebody else's confidential information?
Yeah.
And it's generally it's knowing. I mean, in theory, if something, there's ways that you can recover if they didn't, but usually it's did you knowingly get it from somebody who didn't have the right to give it to you? And those damages can be huge too. There have been large damages awarded there as well. But it's just, the important thing is be ethical in your business practices. But when you have any doubt, quick call to your attorney. It may cost you a couple $100. It can save you hundreds of thousands.
Yeah.
If you get into a case that you shouldn't have gotten into.
Yeah, I think the lesson from this episode is for a lot of people is just be careful. Be careful about what you do. Like, make sure that you're doing your due diligence. For
Absolutely.
Sure. Yeah.
Absolutely.
All right. Well, I appreciate all that information, and we appreciate all of you listening. To get help with anything related to intellectual property or to learn more, visit batemanip.com and get in touch with Rand Bateman and his team. Rand, always great having you here. Thanks so much for all the insight.
Thank you very much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.